Welcome to our channel and thank you for clicking on this video regarding the South African Employment Equity Act. This is video 1 of 4. If you are an employee representative on an Employment Equity Committee or Grade 12 learner, you will benefit from watching these videos. Please note that this video is not a complete summary of the Act. There are other videos on this topic as well. New law may also come into play after the publication of this video. All Grade 12 learners should consult their school's curriculum for other relevant content. We hope that you will find these videos helpful. Please subscribe to our channel, give us a thumbs up if you find the content useful, and share it with others. This way we will be able to add more videos with quality content. If you are preparing for your Grade 12 examination in business studies, you should return to this video often. It will ensure that you get a proper understanding of the South African employment legislation. Remember, practice makes perfect. So let us dive into the content of video 1. The Employment Equity Act has been in place since 1998 with various amendments made to it over the years, such as the Amendment Act of 2013, Amendment Regulations of 2014, and the Amendment Bill of 2020. In the video description you will find more information, web links, and references, but please note that the 2020 proposed amendments are not covered in videos 1 to 4. The Department of Employment and Labor is responsible for monitoring and evaluating the implementation. To do this, it needs to receive regular reports from companies regarding compliance and progress. Regular reporting to the department is a legal requirement for designated employers. The purpose of the Act is to achieve equity in the workplace, by promoting equal opportunity and fair treatment in employment through the elimination of unfair discrimination, and implementing affirmative action measures to redress the disadvantages for designated groups, and to ensure equitable representation in all occupational categories and levels in the workforce. If implemented correctly, this Act focuses on capacity building while ensuring that employers create a sustainable employment practice that will empower the historically disadvantaged. Whilst seeking to achieve the ultimate goal of equality, the Act acknowledges the economic realities of the private sector and the requirements for an organization to be successful. It does not expect change overnight, nor does it require organizations to implement quotas blindly without considering workplace realities. A designated group means Black people, women, or people with disabilities. In this context, Black people is a generic term that refers to African, colored, and Indian people. The Act applies to all employers and employees with specific mention to designated employers. A designated employer has additional responsibilities and refers to employers who employ 50 or more employees or have a total annual turnover as reflected in Schedule 4 of the Act. For designated employers, different sectors have different thresholds regarding company turnover. For more information on sectoral thresholds, you should refer to the Department of Employment and Labor's website. Employers can also volunteer to become a designated employer. The South African National Defence Force, National Intelligence Agency, and South African Secret Services are excluded from this Act. Non-compliance. Should a designated employer fail to comply with the obligations of the Act, the fine for the first offence is 1.5 million rands or 10% of the employer's annual turnover, whichever is the greatest, and or 10 years imprisonment. Disputes concerning employment equity implementation. An employee, or applicant for employment, may refer a dispute concerning alleged unfair discrimination such as medical or psychological testing or recruitment practice to the Commission for Conciliation, Mediation, and Arbitration, also known as the CCMA. A claim needs to be lodged within 6 months of the alleged discrimination. If a dispute is not resolved at conciliation, a party may refer it to the labor court for adjudication. The parties to a dispute may also agree to refer the dispute to arbitration. Unfair dismissal disputes in which unfair discrimination is alleged must be dealt with in terms of the Labor Relations Act. the dismissal must be referred to the CCMA within 30 days. This brings us to the end of video 1. We hope you found it helpful and that you will continue to watch the other videos on this topic. In video 2 we will cover the duties of a designated employer. Please subscribe, like, and share.